will delete it because we've met the requirement for public hearing. So do you have a position one way or another if you want this on?
Oh, that's fine.
So we're good to go here on this. All right. Anybody need to take up anything before we go on the record?
Judge, I just wanted to mention to Mr. Larrimore, if you can give me one moment, I want to talk to him about the waiving his appearance in person. I forgot to mention that with him. You can give me one moment.
And before we get started, what about the preliminary hearing? Has there been one in this case or a waiver?
No, Judge, we're going to waive.
Okay.
Let me talk to him real quick. I forgot to do the Zoom thing, though.
You bet.
Excuse me.
Amanda, can you hear me fine? I'm having some connection issues.
Yeah, I've so far, whenever you've spoken, it's been clear, not broken up at all. Can you hear me all right?
Okay. Well, I'm on the VPN network and sometimes the picture, our office server.
Mm-hmm.
And if there's a problem, I can get off and get on my server.
Okay, you did drag a little bit there, but so far it's been okay.
Okay.
Okay, Judge, thank you.
All right, let's be on the record in two cases, those being 2018 CR 1170 and 2020 CR 282, both captioned State of Kansas versus Lucian Larrimore. Would the parties announce their appearances, please?
State of Kansas appears in both cases by Assistant District Attorney Daryl Smith.
May it please the court, Mr. Larrimore appears in person with counsel Brett Richmond via Zoom.
All right. Mr. Larrimore, as your attorney mentioned, we are doing this by Zoom video conference. If you wanted to, we are now doing in-person hearings, so we could all get together and come to court and do that if you wanted to. My understanding is you talked to Mr. Richmond and you're okay by doing this hearing by Zoom. Is that correct?
Yes, sir.
Okay. And as I said, we're going to go over this plea today. In order to do that, I need to ask you some questions. So my court, if you'll raise your right hand, my court reporter will swear you in.
You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right, Mr. Larrimore, how much formal education have you had?
I graduated high school. 12.
You read and write okay?
Yes.
All right. As you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might keep you from understanding what we're doing today?
No.
Feel like your mind's clear to this morning?
Yes.
All right. Do you know what you're charged with?
Yes.
Do you understand that you're not required to change your plea in this case? If you wanted a jury trial on the original charges, you would have that right. Do you understand that?
Yes.
All right. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Do you understand that?
Yes.
Throughout that turning, Mr. Richmond would be helping you. He would be able to confront and cross-examine all of the state's witnesses. He would be able to call any witnesses that you wanted called. If they didn't want to come to court, he could use subpoena power and make them come to court. Do you understand all that?
Yes.
All right. At that hearing, you would have a right to testify if you decided to, but you would also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, Mr. Smith couldn't get up and go, well, ladies and gentlemen, Mr. Larrimore must be guilty because he didn't tell you his side. Do you understand that?
Yes.
All right. If we had that trial and you were convicted, you would have a right to appeal that conviction to the Kansas appellate courts. If you couldn't afford a lawyer to do that for you, one would be appointed to effectuate that appeal. Do you understand that?
Yes.
Now, if we go forward with this plea today, you're going to be giving up all those rights, and there's not going to be any kind of trial in this case. You understand that?
Yes.
All right. I almost forgot before we got started, there hasn't been a preliminary hearing or a waiver in this case. You also have a separate right besides the jury trial right to what's called a preliminary hearing. At that hearing, the state would have to put on enough evidence to prove to the court that there was probable cause that a crime was committed and that you committed that crime. My understanding is you've talked to Mr. Richmond about this and you want to waive that right to preliminary hearing today. Is that correct?
Yes.
All right. And Mr. Smith, on behalf of the state, do you also waive preliminary hearing?
Yes, Judge, in case 2018 CR 1170, the state would also waive preliminary hearing.
All right. Mr. Richmond, anything to add on that?
No, Judge.
All right. I'll find that the preliminary hearing's been waived, find there is probable cause, bind the defendant over for trial. Mr. Richmond, waive formal reading.
Yes, Judge, enter a plea of not guilty for the time being.
All right, I'll enter a plea of not guilty on behalf of your client until we get through this. Okay, so back to where we were at. Do you have any questions about any of these rights that you and I have talked about so far?
No, sir.
All right. And is it your intent today to change your plea from one of not guilty to guilty?
Is it? Say that again.
Is it your intent today to change your plea from one of not guilty to guilty?
I'm not quite understanding that one.
Okay. So up until this time, you have maintained a plea of not guilty. But my understanding today with the changes that are talked about in the plea agreement, that you're going to be changing your plea from one of not guilty to guilty today. Is that
Yes.
correct?
Yes.
All right.
Sorry
So
about
I talked about the plea agreement and this plea petition. I'm going to show you this on the screen right now. Can you see that document that I just put up?
Yes, sir.
Do you recognize that document?
Yes.
All right. This is what we call the petition to enter plea of guilty. Did you have an opportunity to go over this whole document with Mr. Richmond?
Yes. Yes, I did.
Feel like you understand everything in it?
Yes, sir.
All right. And I'm getting down here to the where there's a signature right there above your typed name. Is that your
Yes.
signature?
Yes, sir.
All right. It says in here that this is the plea agreement, that you're going to be pleading guilty to the 2018 case, which is a possession of cocaine, a severity level 5 drug felony, that they're going to recommend to the court an aggravated sentence at the time of sentencing. The state is going to dismiss the 2020 case in its entirety. Nobody's going to be requesting a fine, that you will obtain a drug and alcohol evaluation before sentencing, and the state will agree to recommend probation and not ask for imposition of special rules if applicable. State also agrees to a dispositional departure to probation if necessary. Is that your understanding of the entire plea agreement, Mr. Larrimore?
Yes.
Mr. Richmond, same question,
Yes, Judge.
and Mr. Smith.
Yes, Your Honor.
All right. Mr. Larrimore, has anybody promised you anything else other than this plea agreement that I just read to you to get you to plead guilty today?
No, sir.
Anybody placed any force or threats against you to get you to plead guilty today?
No.
Okay. Now, I see in this plea agreement that there's a lot about the recommendations that the parties are going to make. You understand that those recommendations are not binding on the court. While I'm going to listen closely to what everybody recommends, I have the ability to sentence you to anything that the law allows. Do you understand that?
Yes.
Okay. Now, I'm sure that the parties have talked to you, or Mr. Richmond's talked to you about what he expects your criminal history to be and where you'll fall on the grid. Is that correct?
Yes.
Mr. Richmond, what do you believe Mr. Larrimore's criminal history will be?
I believe it's an F, Judge.
Okay.
Or
Now,
or
I'm-
an E, or an E. There's no person felonies at least.
All right. So, Mr. Larrimore, I'm sure Mr. Richmond's talked to you about what kind of sentence you should expect based on that, but I don't know anything about your criminal history. So what I have to do today is assume that you have the very worst criminal history possible so that I can advise you what the most that anybody could get for this crime is. You understand that?
Yes.
All right. So the most that anybody can get for the crime that you're pleading to is 42 months imprisonment and a fine of $100,000. That would also carry a post-release supervision of 12 months. You understand that?
Yes.
Okay. Do you have any questions about anything that you and I have gone over up to this point?
No.
All right. Mr. Richmond, do you know any reason why your client should not plead guilty?
No, Judge.
All right. Then, Mr. Larrimore, I will ask you, as to the count in case number 2018CR1170, which charges you with possession of cocaine, a severity level 5 drug felony, how do you plead, guilty or not guilty?
Guilty.
All right. Mr. Larrimore, I'm going to ask Mr. Smith to tell me what he believes the evidence would be if we had a trial in the 2018 case. I want you to listen closely because when he's done, I'm going to ask you if that's what happened, okay?
Okay.
Mr. Smith.
Your Honor, were this matter to proceed to trial, the state's evidence would be that on October 19th of 2018, the defendant was observed by Kansas City, Kansas police officers handing a small clear plastic baggie containing a white powdery substance to a Mr. Jurgens in a driveway located near 3901 Rainbow Boulevard, a location in Kansas City, Kansas, in Wyandotte County, Kansas. Officers then approached Mr. Larrimore and seized the plastic baggie, which was subsequently tested by Officer Longoria using a NARC-2 field test, and that substance tested positive for cocaine. And Mr. Larrimore told Officer Longoria that it was indeed cocaine. All of this occurred in Wyandotte County, Kansas on October 19th of 2018.
Mr. Larrimore, is that what happened in this case?
Yes, sir.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered his plea in this case. He understands the nature of the charges, the consequences of the plea. I will find there is a factual basis for the plea and find that the defendant is in fact guilty as charged of possession of cocaine, a severity level 5 drug felony. Pursuant to the plea agreement, I am dismissing the 2020 case. I will order a pre-sentence investigation and defer sentencing until that pre-sentence investigation is completed. 1 second, ladies and gentlemen, I'll ask Miss St. James for a date. Yeah. At what time? July 27th at 9 a.m.
Judge, that date is fine with the state if it gives Mr. Richmond sufficient time to get the evaluation.
That is fine. Mr. Larrimore has already completed the evaluation actually and starts classes next week.
Fantastic. All right.
Good.
Good job, Mr. Larrimore. All right. Sentencing will be set July 27th at 9 o'clock in the morning. Mr. Richmond, discuss with your client. Let me know if you want to do another Zoom hearing or if you want to do it in person. Oh, that is a Zoom day. Are you and your client going to be okay with Zooming the sentencing?
Yeah, that's fine, Judge.
That's
All right.
fine.
And Mr. Smith, you're okay with that too?
Yes, Judge.
All right, I'll send the invite as soon as we hang up here. Is there anything else that we need for our record today?
Nothing for the record, Judge.
Then-
Judge, you have the order for sentence investigation?
I do, but there is something I did forget. Mr. Larrimore, as a convicted felon, it's now prohibited for you to own or possess a firearm, certain kind of cutting instruments like dirks, daggers, switchblades, things, basically knives that could be considered deadly weapons, okay? Mr. Richmond can tell you more about that. my point is, before you decide to have a weapon like that, make sure you talk to a good lawyer like Mr. Richmond. Make sure it wouldn't be reason to revoke a probation or add new charges, okay?
Okay.
All right. Address the revo. Another case. Sorry. Okay. Other things for our record today.
No, Judge.
No, Your
All
Honor.
right. Then we are adjourned. Thank you, Mr. Larrimore. We'll see you in July, okay?
Okay.
Thank you, Judge.
Thank you.
Thank you, Your Honor.